Mr. Wiseman.
Good morning, Your Honors. My name is Brian Wiseman. I represent the juvenile known as Isaiah H. This is a further appellate review of the appeals court reversal of an allowance by the juvenile court judge.
Isn't this so just inextricably mixed up that it ought to be just vacated and done all over again? I mean, what did the judge find here?
The judge found that the police made a stop without reasonable suspicion.
Where is the evidence that the police officer, quote, chased the juvenile into the store?
Judge, the chase is this. Chase is defined as pursuing someone with the intent of seizing a person. Within mere seconds or within 10 seconds of going into the store, the officer was upon the young man. But
there's testimony.
Somehow imply running and a chase imply some sort of running, not walking?
He walked quickly, but he went after him quickly.
Where was the evidence that he walked quickly?
He said that. He went quickly in after him.
Went quickly in behind him.
But he never said there was nothing to indicate he ran in any way.
That's correct.
So how can there be a finding that he chased?
But the finding that he chased is sort of not applicable to the case in that that the stop doesn't happen until he gets into the store. So there is no calling out or yelling to him or saying stop as he chased him. And there's no finding that there's an intimidating rush. What she says is she chased after him. What the chase is relevant is to his ability to make the observations that he says that he made in determining that the defendant
Where is the evidence that the juvenile was placed in handcuffs immediately when the police officer went in the store?
Well, he was seized. He was seized immediately.
He wasn't handcuffed.
No, that's inaccurate.
So that's wrong.
But the fact is, the issue we're contesting here is the seizure, not when he was handcuffed.
How was he seized immediately when the police officer went in the store?
Because the officer went in immediately and grabbed his leg. He said, "Don't move," and grabbed his leg.
He didn't do that immediately. The boy had time to put his hand in the sock, to put his hand in the Cheetos, to straighten up. So the officer didn't immediately seize him.
Well, it was immediately as he came upon him. He says in mere seconds he comes in upon him, and his hand in his sock, as the judge found, his hand was near his sock, not in his sock. And the judge had good reason to find that, because the judge not only listened to the testimony and heard that this happened in mere seconds, but the judge also saw pictures of the store, pictures of where everyone was, and could see from the relative body size, and could decide, based on the officer's description, that he was on the left of the young man and that the young man was bent down.
She could decide those things, but it doesn't. Precisely what we're missing here is her parsing of the details of what she believed and what she didn't. There are these gaps where she's made findings, but they seem a little bit incomplete. She doesn't tell us, I accept this part of the officer's testimony, I reject that part of the officer's testimony, so that we can tell.
Well, I think it's clear that she rejected some of the officer's testimony. That it's implicit at certain points and explicit at certain points. For instance, where it starts, where the officers believe for some reason that they're casing the store, the two young. Well, she explicitly says there's no support for that. There's two persons in front of the store, not even close to each other, because she saw pictures, and the officer showed where they were located when they were watching them. And the officers showed where each of the two young men were, and there's no interaction between them. And the description is that my client is looking in as he's inching towards the store. So the judge finds
But how do we know when she believed him and when she didn't? Because she believed some of what he said, that's clear, because she adopts some of his testimony.
Well, essentially the police are the only witness. In some of the testimony is not challenged, that he had his hand in his pocket and that he was going towards the store. That's not challenged. But the judge explicitly finds that there is no casing of the store, and that my client is just walking towards the store with his hands digging into his pocket as he goes into the store. And this is completely innocent behavior. Based on those first two facts, the officers said they believed an armed robbery is going to take place. And that's all there is at that point. There's two persons in front of the store.
Didn't they testify that there had been a bunch of robberies, both armed and unarmed?
Well, they said that there had been. Basically, they're saying it's a high crime area, but they were not, and the judge found, they were not investigating similar robberies to what they're suggesting was coming here.
But did she make any findings that she found them untruthful when the officer said there were robberies right in the vicinity of this place?
Not in the vicinity of this place, but in the area, that the area that they're at, there had
And
been...
how did she make the finding? She said that there were purse snatchings in the area, not armed robberies. How did she know that?
She said that there were strong-armed robberies.
No, I
The officer
thought
said
But
that
she
said-
uses the word purse
She
snatches.
says, and how did she get evidence that there, was there evidence that there were purse
I
snatchings in the area?
believe the officers had testified that there were what he called strong-arm robberies where purses were taken.
So what, so she didn't believe strong arm robberies, but she did believe the purse snatching?
Well, I believe that's the same thing, that strong-arm robbery is grabbing a purse and running is the same thing as purse snatching. That's the way I understood the
There's a difference
facts.
between an armed robbery and a purse snatch.
But the strong-arm was, I took it to the fact that that meant a unarmed robbery, but
Well, that's what I say. Where's the evidence of an unarmed robbery?
Well, that was what the strong-arm robberies meant, and that...
What?
that-
Strong arm robbery meant an unarmed robbery?
There was no evidence about purse snatching. The officers testified they had recovered pocketbooks taken in the robberies in a nearby yard and were tracking teenagers known to frequent that area.
I thought that fact was being interpreted that strong-arm is grabbing the person.
You're saying strong arm, not armed.
Strong-arm, yeah, not armed.
Strong-arm.
That's the way I took that, and that's what
It's sounding as if you're saying armed, armed robberies. It's strong
strong-arm.
arm.
It's awful hard to really justify this, without doing, doing things we shouldn't do to the Commonwealth. At the same time, if we do what the appeals court did, we're, harming your defendant. That's why I say maybe it ought to go back, because the appeals court supplemented the record with all kinds of testimony and says, here's what really happened. I have real trouble trying to figure out what the judge found here.
Well, I thought that it was clear, but the one thing the judge found is there was no casing, that the person was walking towards the store in rather innocent behavior. The police officers testified they're behind him as they're making the observation of him inching towards the door with his hands in his pocket.
But if there's no chase, then that all isn't relevant.
Well, except that based on those two facts, the police had already decided that a armed robbery was going to take place. That
About the other person looking up and down the street, did she make any finding about whether he was looking up and down?
she did not, but she found that there was nothing between them, and it's clear that she found that there was no casing
If
in
there's
that.
nothing between them, the question of whether the other person is looking up and down the street should have some bearing on that. And she makes again, she may be right to discredit it, maybe she didn't believe it, but it's another gap. To examine whether they're acting in concert, it would be important to know, is one of them looking in the window and fumbling in his pocket while the other one is looking up and down the street?
I think
Here's what she said. She said the officers never saw any interaction between the two males on the street or any movement that would lead them to believe they were together.
I think that's explicitly rejecting the Commonwealth's assertion that they were casing the store, they were working together. I think that could be quite easily read in that way. And that's from her decision. I think it's clear that's what she's saying.
She didn't make any findings, so I assume you're going to say she rejected the officer saying that this juvenile, the other guy was looking up and down the street, but this guy was looking in the store, scanning it, manipulating something inside his pocket. She didn't say anything about that.
Well, she did. She says in the section where she does a legal analysis, she says basically that the person's hands in his pocket going up and down as he's looking into the store.
But
And she said,
what about looking in the store from an angle where the clerk couldn't see him?
well, she must have rejected that, and it's fair
Must
to reject
have,
that
but
as
we
the
don't
police.
know.
I'm sorry. Well, the police are saying that they're across the street on a night as he's looking, and she finds play. He's looking into a well-lighted store.
She
as
said
he's
the
walking
juvenile
towards-
was merely looking into a window of a well-lit open store.
I believe that is her finding regarding that.
Where
bit
does
of
that
evidence.
testimony come from?
That's from the officer's testimony. It's a fair inference from what the officers testified to, plus in conjunction with the pictures that
It
she
is
was
most
shown.
certainly not. The officer described the juvenile, as I'm quoting now, peeking into the store with his hand in his pocket, inching towards the door. The other officer described him as scanning the store, manipulating something inside his pocket, standing at an angle from which the clerk could not see him. So where is the window involved in that?
Again, the judge, unlike the appellate court, has pictures where the officer said, here's where he was, here's where he was, here's where we were, and these pictures show the well-lighted store
But
and
the
where he was.
pictures don't show where the defendant's face was and what he was doing. And disbelieving evidence isn't the same as adopting contrary evidence. If there's no contrary evidence, you can't adopt something contrary to what the evidence is.
Well, if she didn't find it and found something else, I think you can infer that she rejected that
Can't do
testimony,
that.
discredited it.
Just because you don't
Doesn't work
believe
that
someone
way.
doesn't mean that you can adopt the opposite if there isn't testimony to the opposite, testimony or evidence.
Well, a finder of fact can certainly reject and accept
Yes,
testimony
but
based
that's
on...
I assume there was-
something she accepts.
Well, but I assume there was cross-examination of the officers, what they actually could see from where they were standing and all of this. I assume that that occurred, did it not? The officers
To some extent, the cross-examination of where you were and how long did this take place and how long did it take you to get in there. But certainly in direct, the officers show exactly where they were and where they made their observations and how long they had to make these observations. And based on those, the judge has good reason to decide or can infer the credibility or the reliability of the
Right, she
observation.
can conclude that the officer couldn't have seen the face and the eyes scanning the store because he was not in a position to see it, regardless of what he testifies to, and cross-examination can form the basis of that, right?
That's correct.
But she can't say that he was looking in the window of the store because there's no evidence that he was looking in the window.
Well, I think it's a fair inference if that he's walking towards it and his head is in a certain way that it's clear that he's looking into the window.
But she didn't see how his head was. The picture, I assume the picture was of the window, not
That's
of
correct.
the boy in front of the window.
But based on the description...
But she doesn't know where he's looking, and so she can't make a finding that he was looking in the window of the store.
But what's important is the officer is saying that he's looking in the store as if he's casing it, and that is not something that she found.
Well, she could, the officer said he was doing that. She could have rejected that, but she doesn't tell us that she's rejecting it.
I think it's implicit that it's rejected. And basically, she goes out of the way to say it's innocent activity. A person walking towards the store as he's looking in the window is a rejection of the officer's scenario that he is, in a manner, casing the store for potential robbery. She further finds that he goes into the store and goes into the part where he was looking.
Aren't you glad you came today?
But the appeals court found, and this is the problematic part of their decision, is they made their own findings. And one of the findings is that the judge completely rejected is that the officer says he saw him sticking something in his sock, where it's clear that the judge rejected that, and the judge rejected that and said it was he had his hand near his sock. And the Commonwealth asserts that this is uncontroverted testimony only because this is the only witnesses of the police officers. But it certainly was in controversy. It certainly was challenged. It certainly was argued. And
Again,
certainly,
he was cross-examined about where he was and what he actually could see and not, right?
That's correct. In the pictures...
So it is controverted. It's quite controverted.
It's controverted, so it can't be an uncontroverted fact. And the Commonwealth also argues this, and the appeals court accepted this, that my client had responded to the presence of the police officer. The officers say that they were in an unmarked car, and they assumed that the defendant knew what an unmarked car is, but for no reason except that it's a Crown Victoria and it had white walls, and I believe he said that there was no antenna. I don't think it's fair to assume that anybody would know that. Now, the motion judge did not find that he did this in response to the police, but the appeals court relied on that and said that this is a fact that is
Well,
possible.
Mr. Weissman, what if we agree with you that the appeals court added in information or whatever, but we still don't feel there's enough clarity from the trial judge to do what you want us to do? What do we do?
Well, I feel there is enough, but you're asking, I think you're suggesting that it should be remanded for further findings. Is that, but what I'd ask you to do is, based on a record, it's implicit or explicit in what her findings are. And she does find that there's no articulable suspicion of criminal activity, that everything is innocent, and some of these facts don't even exist. The facts that relied on by the appeals court were, one, the case, and she doesn't find that that even exists. So when the Commonwealth says it's a series of innocent activities that mean more than each activity by itself, but where the activities really are that the judge found is that person was inching his way, looking into the store as he was putting his hands in his pocket, which is a very innocent activity, fumbling for a change.
And by the way, this was during, was it the month of
It
January?
was January. It was a winter's day, and it's 9:30 at night, and it seems like a terribly innocent fact for a person to be walking along the street, looking, as the judge found, looking into the store, trying to figure out how much change the person has, and to have the person hand in his pockets. There's really no, it's not advanced by the Commonwealth's theory that, or the officer's testimony, that people with unholstered guns are often checking them, because while that may be true, it's more often the case that people with hands in their pocket or fiddling around are doing completely innocent things. So that alone would not be a reason to stop a person, and yet it seems that the officer had decided right away, and that's what they testified to. Right away, they decided that an armed robbery was going on. That's why the judge addresses that at that point, saying that there's not reasonable suspicion. So the Commonwealth says, well...
Mr. Wiseman, your time is up.
Oh.
Thank you. Mr. Mazzoni?
Good morning, Madam Chief Justice. Dean Mazzoni, Assistant District Attorney for the Suffolk District on the Commonwealth's behalf. With me is Assistant District Attorney Sarah Richardson, who was the trial prosecutor in the Boston Juvenile Court, and Assistant District Attorney Kathleen Celio, who co-wrote the Commonwealth's brief in this appeal, which is a Rule 15 appeal.
I don't see any way out of this except doing it all over again.
No, I respectfully disagree. I think that when the question is whether or not the trial judge, the motion judge here, found these officers credible, that is, whether she credited their recitation of historical facts on the night of January 30th of 2003, I think it's beyond dispute that she, in fact, credited those facts. She was wrong on the law, and that's what's leading everyone into this confusion. She was wrong on the law.
Well, didn't she conclude that the juvenile was merely looking in the window as a fact?
As an historical fact.
Okay.
As an historical fact, absolutely, as an historical fact. But the problem, as Commonwealth v. Kennedy is cited in my brief, is that she is putting as innocuous a gloss on every movement of these juveniles as she can. And this court has said in Kennedy, and the Supreme Court has said in Terry v. Ohio, that that is not what we do as a matter of law. A reviewing court are supposed to look at these historical facts through the lens of experienced, trained police officers who are there at 9:30 at night in B3, where they're in the area. There have been armed robberies, and just for the court so I don't forget, pages 7 and 25 have the tutorials on strong armed robberies and just what they are. In that context, for Detectives Dugan, Black, and Heron to notice the defendant, Isaiah I., the juvenile, peering into the store with his hands, importantly, in his front pocket, manipulating an object. There was testimony on this from the experienced, trained officers about what they knew about those kind of hand movements. And then to see another young male in front of that store looking up and down the street.
She doesn't find any of that.
She doesn't not find it either.
That's correct. And as this court has done on numerous occasions, as the appeals court has done on numerous occasions, as reviewing courts customarily do, they have supplemented uncontroverted facts.
Well, yes and no. Here you've got a judge, if you look at what she did, where you get the clear impression she did not believe these officers, did not believe them, that they saw these two black males looking around the store or in the store and decided, look, we're going to go get them. And there's been a few robberies around here. And in effect, chased them into the store. That's what I get out of her findings. And all this other stuff about they were casing the store and one was looking up the street and the other one was positioned where the clerk couldn't see him and all that stuff, I think she found was phony.
I can't disagree most respectfully, Mr. Justice Greene, more strongly. She believed those historical facts. The question became what sort of a spin or inference she would draw. She thought she could legitimately draw from those facts, and that's a question of law. And she was wrong on the law the whole way.
If she believed them, why aren't they in the findings?
Because she thought they weren't necessary. Because when she makes as a matter of law and as a finding of fact, which is erroneous, that Detective Dugan chased Isaiah I into that store where there's no support in the record, where my brother and I listened to the tape, and all Detective Dugan says is that he did Commonwealth v. Laureano, I went in behind him. As soon as if you read a natural reading of her findings and rulings, I think compels the conclusion that she thinks a seizure occurs at that point. And then she doesn't have to worry about whether the hand was near the sock or stuck inside the sock or Cheetos or Fritos or any of that. She was wrong on the law.
I'm really having a hard
that's-
time following you here.
Sure.
She concluded, for example, that the individual was standing in front of the window on a cold night, an open store, I assume a convenience store, with his hand in his pocket. And in her view, that was not suspicious activity. Is she supposed to simply say, well, but the officer says in his view it was, therefore I should find it suspicious activity?
Justice Cordy, the answer is that characterization of what that Isaiah I was doing on that night is a question of law.
It's a question of law?
It is.
I find you standing in the store, standing in front of the store with his hand in his pocket, okay, looking into the store. It's an
Yes.
open store on a cold winter's night.
Yes.
Right? That's what I find. I don't find that's an adequate basis to support reasonable suspicion to stop this gentleman to search him for a weapon. Right? But the officer said, well, I did, because I really think, based on my experience, that a young black teen standing in front of a store in this area with his hand in his pocket may well be wanting to rob that store.
That's Terry v. Ohio and Commonwealth v. Kennedy. The historical...
So we have to defer to that supposed expert analysis, even if the judge rejects it as being unreasonable?
Commonwealth v. Kennedy. It's the silent movie. That's for this court to decide. And under the cases, the applicable cases, Detective Dugan absolutely, without a doubt, had reason to believe that Isaiah I was armed with a weapon in that store. I would say Commonwealth v. Frazier and Commonwealth v. Yantai Fisher, which is an excellent appeals court case, with the facts that are exactly the same.
So she found that he didn't put something in his sock, all right? You say that we can reject that because the officer testified that in his view he did put something in his sock. Isn't that a question of fact?
She found that the hand was near the sock, that's all he found.
Right.
But that's not supported by the evidence, and there's no factual basis.
There was no cross-examination, for example, of the officer as to what he actually could see based on what the setup of the store was and where he was, what leg he supposedly saw?
Mr. Wiseman he's a very good attorney. He said, isn't it fair to say that he was just making some adjustment to his sock? And Detective Dugan unequivocally said no.
And there was a cross-examination about where the leg was compared to where he was when he made the observation?
Well, there's no doubt that Isaiah I's left side Isaiah I is bending down. Detective Dugan comes at him on his left side. Detective Dugan sees him stick something in his sock. Isaiah I looks, turns, sees Detective Dugan. As soon as he sees Detective Dugan, Isaiah I gets up, pant leg drops down. Isaiah I starts rooting around in the Cheetos, and at that time, Detective Dugan says, "Stop, don't move," and he grabs the gun.
And if the judge finds that his hand was not, he did not put something in his sock, you say that, well, sorry, you can't find that. The officer said he did.
No, I don't say that at all. I say there is no basis for her to, as Justice Cowan was I think exactly right, that you can't adopt facts that were never testified.
But you can reject facts. You can reject facts that are not credible based on cross-examination and review of all the evidence, can't you? Isn't that what fact finders do all the time?
Except part of it. And it seems to me what she does is she accepts that he was leaning over, that the hand was down near the sock, but she's not going to credit the further detail that he was physically sticking something into it. She's been convinced that from the timing, the angles, the distances, the who was where, that he wouldn't have seen that much. And therefore, as far as she can go is his hand was near the sock. Isn't that a perfectly permissible inference for her to draw after the cross-examination?
I don't think so. I think as she writes in her, I'm sorry.
It's our standard instruction. We tell juries all the time, you can believe all of what a witness says, none of what a witness says, or you can pick and choose and believe part of what the witness told you and disbelieve other parts.
That's correct. And the judge as a fact finder is perfectly free to do that. Having said that, now that we're here on appeal, the question becomes when an appellate tribunal, this court or the appeals court, can come to a settled determination, and it can in this case.
But isn't
that
the problem
the historical facts were credited?
Isn't the problem that the police may well have had good reason for what they did, and based on their experience, their knowledge of the area, They may have been perfectly justified in what they did, but the problem is that we don't know from the judge's findings what she found and what she didn't find, and what she believed and what she didn't. And isn't it therefore necessary for it to go back for some findings to be made?
On page 13 in the Commonwealth's appendix, right at the beginning of the final paragraph, where under the second paragraph, conclusions of law, the officers did not have a reasonable suspicion to stop the defendant, period, based on the facts as presented. And then she goes on and adds some facts. The only facts that were presented in this case were the facts that were presented by Ms. Richardson, the Commonwealth, at that motion hearing.
Well, based on the facts she found, the officers had no basis to do what they did.
I don't think that's correct. I think she is not including.
To get where you want to be, we got to do what the appeals court does, which is to find all kinds of other stuff.
Additional facts.
No, they're not finding facts. They're supplementing uncontroverted facts. I think the question this court has to answer, and I think and I'll answer it, is that whether the historical facts, whether from this record, we can infer that the historical facts.
What if she had said?
She didn't think the other facts meant anything, because as far as she was concerned.
How do we know that?
Because as far as she was concerned, when the chase occurs, that's where her analysis starts. That's when she takes Tebow, right, the classic, the stop starts when pursuit begins. But she's wrong, because this isn't Tebow at all. This is Laureano. And from there, from that point, from that infected route, the whole
She doesn't
plant,
even cite Tebow or Laureano.
That's right. She does not. She died.
What if she had said that she disbelieved the officers with regard to putting something in the sock and so forth? You wouldn't be here, would you?
I think it doesn't matter even if she said, I do not believe that he was sticking his hand in the sock. I don't know what she could find at that point. I don't think she could find anything.
So if he's got his hand near a sock or even adjusting
I
his
think
sock?
even if he had his hand near a sock, I think there was certainly under Fraser and Yantai Fisher. Yeah, and I don't want to belittle my argument, which is important, my earlier argument, but I think it's fair to say that even if the hand was near the sock, and the appeals court kind of questioned me on this at the time, it would still be Detective Dugan still had an absolute reason to believe that Isaiah I was armed and dangerous, even if the hand was near the sock, even if we take that historical fact, Justice Cordy, as the fact found.
And that's because he had his hand in his pocket.
Manipulating his pocket while he's peering into the store, while his friend is.
Haven't you ever seen a man manipulate his body? I mean,
sure. And I've seen two people on a street corner, hand each other tickets to the Nutcracker. But if I'm an experienced police officer and I recognize one of them as an addict, and I know what this area is an area where drug deals are done all the time, and I recognize certain other indicia, then under this court's jurisprudence in a Kennedy.
Did we send it back to her to find what part she believed and what part she didn't believe?
If you were to send it back,
you're sunk at that time. Probably, aren't you?
The other guy was sunk.
Mr. Mazzoni, that was really my question. We sent it back. The tapes exist, correct? Have they been transcribed?
Yes.
They do. So we send it back and say, she's got, barely a page of findings, which is okay in some circumstances, but to say to her, please make findings as to what evidence you rejected, what you didn't, what you found credible, what you didn't, and then maybe she reaches the same result, but at least we've then got a record. The difficulty, as you can hear, that the court is struggling with is, I know you think we can't do it because it's, quote, uncontradicted.
It's something this court does all the time.
Okay, if we send this back, if we decide that we want to send this back for further findings, do we send it back to this judge or to a different judge?
Different judge.
Well, then you got to do it all over again.
I think it would have to be a different judge, but I don't think we need to do it all.
Why would it have to be a different judge? We send it back to the same judge.
I think just I think the appearance, and I'm kind of just free associating. I think
that's my whole point when I started. If we, one way or the other, if we decided on this record, we're either being terribly unfair to him or terribly unfair to you.
I don't think so. I think on this record, it's evident that she believed, based on the facts as presented, that she was going by historical facts that she credited. She puts a gloss, a legal gloss, on all those historical facts that...
Mr. Mazzoni, I know that argument, but when it is not at all unusual for us to send a case back where we determine that we cannot, based on the facts found, because they're facts that are not found one way or the other, to send it back to the trial judge who heard the evidence. Now, she will be, I'm sure, aware of the fact that she can't put legal glosses. It's the factual findings. In part, there appear to be facts in the conclusions of law that are not recited in the facts, and it's very hard for me to know whether she's making a factual finding or a legal conclusion drawn from facts that she hasn't specified.
There is no fact that she relates in her order. There is no single fact that could lead anyone to think, unlike Pradeep Scott, for example, that could lead anyone to think that she disbelieved the facts that were being testified to on the stand that day. She credits them. That's all she bases her rulings on. Are the facts. But what she does
But then why did she find that his hand was just adjusting his sock? If she believed what the officer was saying, she wouldn't. Right.
I think that's the one. That's the one. In fairness, just that's the one error, and it occurs at an erroneous finding. That doesn't. I disagree that it really bears on credibility. For her to find that the hand was near the sock doesn't necessarily, and it really doesn't at all. It doesn't follow that she disbelieved Detective Dugan when 6 weeks later, after she's writing her findings and rulings, after she's already allowed the motion, that she says the hand is near the sock. And I think the problem is, as far as she was concerned, the analysis ended when what she describes as a chase occurs. And there was no chase. And that's why we're here today. And I see that my time has expired. I thank this Court for all its time and attention once again, and urge this Court to vacate the order and deny the motion. Thank you.
Thank you, Mr. Mazzoni.